Our favorite legal eagles, constitutional attorney Robert Barnes and former Deputy Assistant Attorney General and former U.S. Attorney Harry Litman. Great to have both of you with us tonight, gentlemen.
Thank you, Shannon.
Good to be here.
Okay, so let's start here. We want to play a little bit more about what Rudy Giuliani had to say yesterday about possibly sitting down and what he expects first.
And if they don't show us these documents, well, we just going to have to say no. Let me emphasize, he wants to explain that he did nothing wrong. It's us, the lawyers, who have to convince him that this is a trap.
Robert, fair to say it's a trap?
Absolutely, it's a trap. The entire investigation has been not about exposing any Russia collusion, but about covering up the illegal spying and lying the Obama administration engaged in against an opposition political party and President Trump. So Rudy's basically, his core convictions are precisely correct. It would be a major mistake to sit down and engage in an interview with someone who is not in good faith producing information that's relevant to the investigation and relevant to the defense.
All right, Harry, how does this work when you are potentially a person of interest? We have to be careful with the language we use here. A subject, somebody who's involved, who may get involved, to ask the potential prosecutor to see the information that they build their case on.
Is that for me, Shannon?
That's for you, Harry.
There is not a defendant in the United States, including the President of the United States, who has ever been entitled to see this information. He can see it in court if there are charges. It's a completely unprecedented request. As to Robert's general point about SpyGate, or echoing Rudy here, you know, there are two problems with this SpyGate claim. One is the spy, the other's the gate. Dr. Halper is by no means a spy. The notion is to try to have overtones of Watergate or J. Edgar Hoover. There is no embedding of an FBI employee in the campaign. Rather, there's the use of a confidential informant, completely routine, from bank robbery to any crime, when, I remind you, the FBI had received information, credible information, that Russia was planning to do a campaign to try to influence
Harry,
our election.
Are we talking about semantics here? Because people want to quibble over, you know, whether it's somebody that you don't know is contacting people, getting information from them, and feeding it back to a federal agency. Robert, some people call that spying.
Well, that's exactly what it was.
But semantics really, no. Robert, semantics really matter here. What spying implies, as in Watergate, and this is why they're using it, is the notion of one party actually putting an agent in the ranks of another.
Let me ask you that, Robert, does it matter if that person's embedded or if they are on the fringes of the campaign and have contacts and feed that information back?
I've done a lot of cases involving government misconduct, and every single time they hid behind confidential informant. My guess when it comes out, Stephen Halper will have never been identified as a confidential informant. His main partner in his company in the UK is the longtime head of the MI6, which was the spy agency that formed the first dodgy dossier about getting the UK into the Iraqi war. So clearly what Halper did here was infiltrate the campaign for the purposes of both spreading disinformation and for gathering information, and by anybody's definition, that's called a spying. And because they were doing it in such a way and have tried to cover it up after that, that's the gate. So that's why it's SpyGate.
Okay, all right. With that explanation, Harry, listen, you say that this is so unusual that no defendant would have this potential access to information. But this is so different. This is a sitting president of the United States. His legal team says that if he's subpoenaed, they'll fight it all the way to the Supreme Court, and you know they would. But this is a kind of a negotiation here. His legal team keeps publicly saying, we don't want to do it. He definitely wants to do it. He tells the cameras, and every time we ask him, he wants to do it because he believes he's innocent. It may sound unusual, but this is a very unusual case. Is it just part of the negotiation?
So I agree with that. First of all, he has been saying for months, I want to do it. At this point, we think maybe he doth protest too much, and that, in fact, he's trying to avoid it. But I agree that this sort of ploy, asking for something no one should get, because he's the president, is really a maneuver to try to sweeten the deal for when he does interview. If he goes to court, I'm rare among this on the left, by the way. I don't think it's cut and dried. I think Mueller will win, but I think Trump wants to avoid going to court, and this is part of the negotiation. I basically agree with you.
Robert, just very quickly, we're out of time, but what do you think happens if they take the subpoena fight to the Supreme Court?
I think, as Justice Story said a long time ago, that the president cannot be subject to criminal grand jury process. And I think what this request reveals is that it isn't President Trump who has something to hide. It's Bob Mueller and the Obama administration that has something to hide.
We shall see, gentlemen. Robert and Harry, always great to have a great debate with you guys.
Thanks
for
very
joining
much.
us.
Thanks, Robert. Bye-bye.
Thank you.